Please be seated.
Your Honours, I'm sorry. I understand that I kept Your Honours waiting. For some reason, I thought you said 4:10 after all that. So I do apologise.
Thanks for the apology, Ms. Corner, but save for your confession, we wouldn't have been aware of it.
Confess and avoid has disadvantages, Your Honours.
Časni sude.
Your Honours, yesterday the prosecution showed in their own way and quite effectively so the crime committed at Koričanske stijene and the supposed role and position in that of my client, Mr. Stojan Župljanin, in respect of these events. The prosecution did so by picking out specific evidence and portions of evidence in order to place my client within the context of a joint criminal enterprise. I will now be dealing with the other part of evidence that relates to this incident, but that was not shown by the prosecution either in their closing arguments or brief. One of the charges or accusations was that Mr. Župljanin, in spite of the fact that there were several survivors who gave statements, could easily identify or establish the identity of perpetrators. I will now show you P1567.
Your Honours, I rather think that may have been partly in private session, that part of the transcript. It's an exhibit, but the actual part of the transcript.
But I take out all necessary measure. So this part of statement is without the name and without any further. Gospođa Korner pominjala jednog od preživjelih.
Ms. Corner mentioned one of the survivors and the fact that he gave several statements to the judicial bodies and the police. This is a portion of the statement given by this individual, referred to by Ms. Corner. Please look at what it is that the individual said when the police asked him about the identity of the perpetrators. Somebody shouted that they should come out and that an exchange was about to take place. They were lined up in two lines near a gorge, facing the gorge, and as they had to bow their heads, he saw nobody from the police, nor did he see who was lined up except for those who were closest to him. When the shooting started, he does not remember what happened afterwards.
Časni sude, ovakve su izjave.
Your Honours, this was the kind of statement that all the survivors gave. In other words, none of them were able to identify the perpetrators, although they were questioned by a policeman and the investigating judge. How could then Stojan Župljanin know who the perpetrators were without resorting to some other measures? Furthermore, the prosecution also dealt with the attitude that Mr. Župljanin took in relation to this incident, relying on the statement of the chief of the forensic technicians team. I will present to you what it is that Mr. Župljanin said. You had occasion to see this not in the statement that was modified and prepared by the prosecution, but live. Witness page at transcript page 1448 said the following.
To this. When I met with Chief Župljanin in private in the morning before the meeting, I noticed that he appeared to be shaken. He was visibly shaken. He condemned the incident strenuously. He called a spade a spade. He said it was a crime. To je ono što je.
This is what Stojan Župljanin said. This is the gist of his attitude towards this event, this incident. At transcript page 1451, witness page goes on to say, on the issue of how Mr. Župljanin treated the survivors, and I quote,
I'm personally responsible for the security and safety of that person, and that I should bring him as soon as is possible to the Security Service Center in Banja Luka. I posle toga, once you arrived at Banja Luka, did you discuss with Mr. Župljanin what will be done with this man? Yes, and he told me that he would be turned over to the Swiss Red Cross. Časni sude.
Your Honor, there are other testimonies in this case, but Župljanin told the witness here that he did everything in his power, and he would do everything in his power to make sure that all the 6 survivors had their wounds treated, would recover, and be handed over to the Red Cross. Had Stojan Župljanin wanted, as the prosecution alleged yesterday, to cover up this crime, why would he then do as he did? Why would he protect the survivors? Why would he hand them over to the Swiss Red Cross? If his intention was to cover up the crime and make sure that nobody came to know of it. Yesterday, the prosecution played a video clip that was filmed shortly after the crime, where Župljanin spoke in public about the investigation in a way to make sure that he would not divulge any details. He did not want to speak of any possible eyewitnesses. And that was only natural that a policeman would speak in such subdued tones when the investigation was still going on. And I want to recall the testimony of Mr. Krejc again in this respect, because he was shown the video. at transcript page 1496 to 97, he answered to a question that was put to him.
That number of survivors of the massacre to the public would put them at risk and would jeopardize the investigation. Is that so? Yes. Well, I suppose that would be the case. I to je časni sude. Nijedna policija na...
Your Honours, no police force in the world would, if there are survivors around who are at risk, divulge any details of the incident. And this is what Župljanin himself made sure he did. Your Honours, the prosecution also tried in their closing arguments yesterday to present the police force as not having done their job properly. Neither in this case nor in the case of killings or murders in Vrbas does that apply. Perhaps this would be the case in an ideal world, but not in Banja Luka, in the area of Krajina, in the course of 1992. A prosecutor who was seized of both these cases testified before this tribunal. I will present to you what it is that he said about the work of the Banja Luka Services Center, and in my view, he is much better placed to speak, than the prosecution, to speak of the abilities of the CSB Banja Luka in this critical period. And he said, I'll quote,
CSB Banja Luka, under the circumstances, did everything to document the crime and created a basis for eventual closure of the case 18 years later. He said yes. And furthermore, Your Honor, kada je
when our learned friend Mr. Pantelic, whom we all miss, as Ms. Korner said herself, when he asked the witness whether the prosecution did everything in their power to investigate and adequately process those crimes. Let me remind you to look at transcript page 14292 and 293, and you will see what he answered. He said clearly that he, as a prosecutor, personally considers that he could have done more. Your Honours, the prosecution, when saying that nothing was done after October 1992, also stated that it was indeed possible. And I would like to remind you of a testimony we heard in this case, where members of the unit who were involved in the crime were deployed and assigned to military units at least until the end of 1992. And they were not available to the police bodies, despite all the efforts made by Stojan Župljanin in order to learn their identity and in order to bring them in. And let me just remind this trial chamber, today, 20 years after the crime, the proceedings are still underway based on the evidence that was collected by the CSB at the time and based on the criminal report that was filed by nobody else but Stojan Župljanin himself. And then when it reached the hands of a more capable prosecutor, has this criminal report been processed in a more appropriate way? Moreover, the prosecutor showed you a document yesterday. According to the prosecutor, that document reveals some of the positions of Stojan Župljanin. The number of that document is P583. I would like to call up the documents. We were not able to present it as a PowerPoint document, so I would like to call it up in e-court. I would like to display page 2 in this document and the same page in the English version as well. Your Honor, here the prosecutor claims that Stojan Župljanin resisted, or rather he demonstrated his discriminatory intent. The gist of the document is this. Mr. Župljanin expressed his dissatisfaction with several things. Under one, the police being used to secure and guard people who were detained in this manner. And he believes, and there's a word here which in our language has a totally different meaning. And it was translated as hostages. Taoci in Serbian, hostages in English. Hostages sounds horrible in English. However, I'm going to show you another document. This applies to people who were unlawfully detained without any foundation or grounds for their detention. And it is used.
This is obviously an important document. That's why I raised it. It's not for Mr. Karadžić to give evidence as to the meaning. If he says that is the wrong translation, the word is not hostages, it should have been raised some time ago, and it should be raised now. It is not for Mr. Karadžić to say this is the wrong translation.
Maybe Ms. Korner was not listening carefully. I'm not talking about mistranslation or misinterpretation. I was talking about the way this expression or term or word may be interpreted, may be explained. You will see later on, you will see that there is another term used for this category of people, and the term is isolated. They were isolated. What I'm trying to say with this is that this document should be interpreted in its entirety and in relation to other documents. And when the prosecutor showed his PowerPoint, and I don't know whether there was a mistake in interpretation, and when Mr. Župljanin asked for something that can be seen on the following page of the document that we have on the screen now. Can we go to the following page, please? When he requested something And the prosecutor said that Župljanin requested an action to be taken, whereas in this document it says a clear position. Be it as it may, I'm going to show you what the position of Stojan Župljanin was with regard to this category of people and what actions he called for in relation to these people. Your Honours, yesterday the prosecutor addressed you and showed you a document that I would like to call up now. This is B750. You see, Your Honours, this is a document issued by the War Presidency of Ključ Municipality. In this document, the Presidency informed the CSB about people who were released from Manjača and who belong to the category referred to by Mr. Župljanin. The prosecutor used this document to show that the War Presidency did not have control over public security stations, but that it was the other way around, that the War Presidencies actually implemented Župljanin's orders. This is what the prosecution tried to demonstrate using this document. And this is a trick. Because if you look at this document in isolation, on its own, you might arrive at that conclusion. However, look at the document that precedes this document, which is P607. This is the initial document that Stojan Župljanin dispatched. Look at the heading. It says, to the Chief of the Public Security Station. And then the Chief of the Public Security Station, instead of replying to Stojan Župljanin or taking any kind of measures, actually went to his own War Presidency, and the War Presidency then answered Stojan Župljanin by saying the public security station is not capable of taking the necessary measures. And here, Your Honours, from this letter, you will see what the position of Stojan Župljanin was with regard to these categories of individuals. In the third paragraph from the top, where it says, however, there is some information that indicates that word illegible, it should be isolated individuals. This is a bad translation. And this is the category that it existed in our system. And as Mr. Zečević said, the prosecutor did not interpret the legal terms and the legal system in the way it existed in the former Yugoslavia. Because in the former Yugoslavia, in the Yugoslav legal practice, the term isolated persons or hostages, we all know that it was illegal to keep hostages, but this refers to people who were detained or kept without any grounds for that. And what is the position of Stojan Župljanin with this regard? Let me remind you. It says to their obligation to take appropriate measures to protect these individuals, guard their houses and property, and prevent any attempt at threatening or in any other way intimidating these people or applying force against them. Moreover, it says, any possible incident, event, attack, or any other form of threat against these people should be thoroughly analyzed by operational, tactical, and criminal experts. Everything should be recorded and the necessary measures taken to identify and arrest the perpetrators of these crimes. And then Mr. Župljanin went on to present his categorical position vis-à-vis these people. In cooperation with municipal bodies, the Red Cross organization, humanitarian organizations, and other bodies, if necessary, these people should be provided with food, accommodation, medical, and other forms of help when they returned to their former places of residence. What I'm saying with this, Your Honors, maybe taking it much further than Ms. Butler said, when you judge Stojan Župljanin and when you make a decision on his responsibility, and I am taking this further, you should not be reading the prosecutor's final brief carefully. What I'm saying is that you should not even attempt to read that part that speaks about the responsibility of Stojan Župljanin. Instead, you should be reading the evidence. Because the tactic of taking things out of the context, taking documents out of the context, and linking them up in the way it was done in the prosecutor's final brief is not going to amount to much, and it's not going to take you anywhere. Moreover, Your Honors, the prosecution, in their final brief and yesterday in their closing argument, dealt with what happened in Predo during the takeover. And yesterday, the prosecutor showed you an excerpt from Simo Drljača's document about the number of policemen and the way the power was taken over. I invite you to read this document, and when you do this, could you please also refer to the testimony of witness Jankovic, who commented upon this document when asked about the number of police officers.
On ovdje kaže,
he says when it comes to the number of police officers,
it tallies with my figures more or less according to the books. But as for his numbers of policemen, etc., no way. 1,300 policemen? Where did you come up with that? No way. It's an exaggeration. Before the war, entire station had 230 employees.
And when you judge the possible role that the police played in the takeover of power in Predo, please bear this testimony in mind. Your Honours, And now I'm going to address another topic, and that's the special unit of the police. And since both the defense and the prosecution in their final briefs and the prosecution in their final closing argument dealt with that unit, if you looked at the documents that were presented and that were highlighted by the prosecutor, you will see that the two documents that were presented were issued at the beginning of war in Bosnia and Herzegovina. And you will see when that unit was actually established. That unit was established at the moment when nobody actually knew what the role of the JNA would be in the territory of Bosnia and Herzegovina, because the JNA was in the process of withdrawing and the Army of Republika Srpska had not been established yet. That is why the Assembly of the ARK and not the Ministry of Defense of Republika Srpska issued a decision in order to establish that unit. Because only the MUP of Republika Srpska had the authority to establish such a unit, but he failed to do that. From the evidence presented by the prosecutor, you saw that the CSB played a certain role in the setting up of that unit. However, when the Army of Republika Srpska was established, it is our position that both the structure and the goals, as well as the composition of that unit, were changed. And that is why the unit became predominantly a military unit. This shows that that unit was composed mostly of the troops and a minority of the police officers who had the necessary experience. The formal or the official commander of that unit was Captain Lukic. He was appointed by Colonel Stevilovic. The organization of the unit, as described by several witnesses in this case, and I would like to highlight witness EZ02 on transcript pages 25419, 25418, and 25655. Moreover, the prosecution say in their final brief that Echim and Sabagia were members of the SDB and that they were factually the detachment commanders after Captain Lukic was injured in a traffic accident in late May. This claim, your honors, is a far cry from the truth. When you listen to the testimony of witness Gajic, who spoke about the disbanding of the unit, and when you saw who were the people who were present there at the time, and let me remind you who they were. You will find that on transcript page T10760 and 10796. The commander of the unit at that meeting was there, and he objected to the disbanding of the unit.
If you pay attention to the testimony of witness Tutush, transcript page 968, you will see that in July 1992, the commander of the unit, Captain Lukic, together with Captain Dubočanin, exerted pressure on Tutush to release the arrested unit members.
jedinica je imala svog komandanta svo vreme.
So the unit had its commander all the time.
U paragrafu 721
in paragraph 721 and 833 of the prosecution final brief, it is claimed that Župljanin was authorized by the minister to set up, equip, finance, and maintain special units of the CSB. Of course, this is not contained in any document. A document which has to do with the reorganization of the MUP because of the war conditions is the one that is quoted by the prosecution. Further, in paragraph 748, the prosecution claims that, I quote, Župljanin must have been aware of the activities of these police units on the basis of regular reports and meetings with SJB chiefs. Once again, a term that my learned friend Ms. Butler dealt with, that he must have been aware.
postupku časni sude.
In this trial, Your Honor, after the outbreak of conflict in May 1992, there was just one collegium held on the 30th of July 1992, which was held, and Župljanin's urgent reaction on the basis of what he learned at the meeting is contained in Exhibit 2D25. It is a document that was drawn up on the very same day. In paragraph 974 of the prosecution final brief, the prosecution claims that Župljanin ordered the release of 2 members of the special police from the Banja Luka prison. If you have a look at what witnesses ST123 said on transcript page 7968 and witness SZ002 on transcript page 25713 and 25714, who requested that these men be released, and what Župljanin essentially wanted. And it was not that the men be released, but that they be handed over to the judiciary organs in order to avoid a conflict between the army and the police.
Ja se časni sude neću baviti dalje.
Your Honors, let me not deal any further with the claims in which the prosecutor talked about the links between the CSB and this unit, because I think we have already said quite a lot about that in our own final brief. Only when it comes to the link, this is the paragraph 723 of the final brief about the SOS and Župljanin's relation to them. Let me quote witness ST123 on transcript page 7780 and 7652 when he talked about engaging SOS with the police, and when he said that Župljanin was against members of the SOS joining the police. but that he was unable to prevent this. Further, in paragraph 738 of the prosecution file brief, witness ST197 is quoted. The prosecution uses his words to illustrate that Slobodan Dubočanin was never placed under the command of the 22nd Light Brigade. The defense claims that Slobodan Dubočanin, firstly, never was a member of the special unit, that he was a member of the army, holding the rank of captain, who spent late summer and early fall of 1993 under the direct command of the commander of the 22nd Light Brigade. Exhibit, which I refer you to, is 2D63. Please have a look at this, Your Honors. This is Slobodan Dubočanin's file card. You have had the occasion to see it. From the 12th of September 1992 up until the 20th of October 1992, he is in the military post 7404 Kneževo. The claims of witness ST197 were directed at evading his own responsibility for the actions of units which were subordinate to him. My learned friend Mr. Aleksić will talk more about this. You have heard that most of the criminal activities committed in Kotor Varoš could be traced back precisely to Slobodan Dubočanin and his unit. Further, Your Honors, the defense also wants to clarify a dilemma which the prosecution may have about our position with regard to the alleged murders in front of the health center in Kotor Varoš. Firstly, in order to make myself entirely clear, the defense claims that the special unit did not have anything to do with the murder committed in front of the health center, and that during its cross-examination of eyewitnesses, it opposed the claims that the special unit was involved in this crime. Your Honors, the prosecution founded the count of the indictment relating to this event on 3 documents. The first of these are the minutes from the crisis staff meeting in Kotor Varoš, P46. The second is P1790, which is a report of the 2nd Krajina Corps. And finally, a report of the so-called expert Brown, who erroneously linked these 2 documents in the Talić case and whose work from the Talić case was admitted into evidence in this case.
Znači, da budem jasan.
So, to make myself clear,
događaj o kome govori
the incident about which the first document talks, the one from the crisis staff, was the most difficult day in Kotor Varoš, when there were 6 dead Serbs and some wounded who were brought to the health center. That was one incident. Another incident was the massacre against special police members, which happened on the following day, and about which the 1st Krajina Corps reports. And the third incident is the murder in front of the health center, which occurred between these 2 dates. And this is what Brown accepted as his wrong conclusion, namely that these were 3 separate incidents.
A odbrana je samo dokazivalo.
The defense only tried to prove during the cross-examination of the survivor that the special unit was not involved in the incident, but that the incident was committed by the locals, and we deal with this in our final brief. Further, Your Honors, yesterday the prosecution, and the day before yesterday as well, the prosecution showed you some photos from Kotor Varoš, actually one photo on which one can see men with red berets walking down a street, as if they were models. No shooting is going on, there are no signs of combat, and I recall that when this exhibit was shown to SZ02, this is what he said on transcript page 25818. This man whom the prosecution showed to you yesterday walking around, and these other men were not members of the unit, because the prosecution also showed you the film of the parade with the unit members. Did you see any red berets among the members of the special unit from the month of May? Did you see any green uniforms in this video clip?
Your Honor, I will now be dealing with the defense position in respect of detention centers. It relates to paragraph 761 of the prosecution final brief, where it is asserted that the Manjača camp was in fact a police facility, although it was primarily secured by the army. The prosecution, the defense want to recall the prosecution witness, ST-172, transcript page T-5266, and page T-5267. This testimony will clearly indicate who had the authority over Manjača. The witness confirmed that at no point did a single civilian policeman enter the camp, because all the policemen who were ever there to secure the camp had been resubordinated. It is the position of the defense, which is firmly supported by evidence, that the civilian police who accompanied or were the escort of the prisoners there, or guarding the prisoners, were resubordinated and were given an assignment that fell outside of the scope of activity of the Ministry of the Interior. The relevant reference is witness ST-139, transcript 8691, ST-172, transcript 5281, P1284.55, and 1D43.
Kada je u pitanju Prijedor, mi smo se tim bavili.
On the issue of Prijedor, which we addressed extensively in our final brief,
Sudsko veće šta je u
I would like to remind the trial chamber of the prosecution's position that Stojan Župljanin was informed of the situation in the camps in Prijedor. And let me say what witness, the interpreter didn't catch the code name of the witness, said at transcript page T1126, where he clearly said that Drljača and Pera misled Župljanin deliberately by feeding him misinformation. Let me tell you precisely what the witness said.
That Simo Drljača, Vojin Pera and others painted an untruthful picture of the events that were taking place in the area. They painted a picture that was much softer in terms of consequences. They were documenting information and they could have prevented the crimes, which have been established in their number and nature in both Omarska and in Karaterm and in general area of Prijedor municipality.
Mr. Karadžić?
Yes, sir.
What was the pseudonym of that witness?
Časni sude, to je svedok.
Your Honor, that was witness Radulović.
Thank you.
Ja malo pre, pošto sam se izgledao.
Since I disclosed a couple of names a moment ago, I am now using their pseudonyms in order to avoid any inadvertent mistakes.
763.
At paragraph 763 of the prosecution final brief, where the mistreatment of prisoners at Teslić is discussed, the prosecutor maintains that Župljanin did nothing upon learning of the mistreatment of prisoners in the SJB building in Teslić. Your Honours, can anything be further from the truth than this statement by the prosecution? We have heard here countless testimonies about how Župljanin organized the Mićo's group's arrest in Teslić, how he removed the chief of public security and the commander of the station, Markočević, for their failure to protect the non-Serbs, and he appointed Radulović as acting chief of public security station. He undertook a criminal procedure against them and secured the release of the Croats and Muslims from detention. Perhaps we found ourselves in different places, we and the prosecution, since the prosecution dared to come out with a statement such as this one. Your Honours, as for Sanski Most, I will not be dealing with this in detail, as it has been addressed in our final brief, but it is obvious that all the evidence related to this territory demonstrates that Župljanin had no authority over detention centers in Sanski Most. Or any other detention locations in that town. This applies to Ključ as well, where there is only one post festum report, which is P 960.24, where Chief Kondić says that there are reasons to undertake criminal proceedings against all these men, and they should be prosecuted for the crimes they committed, and they should be prosecuted before a military court as soon as may be.
Donji
Vakuf, we addressed it in our final brief, was under military administration, and document P1927 clearly indicates that the detention or the collection center in Vakuf was set up in the month of May by the command of the 19th Partisan Brigade. And this claim that all the detention center in Republika Srpska were under police authority is absurd. In paragraph 367, the prosecutor says that Župljanin allowed the mistreatment of prisoners in CSB, and they quote ST27 as their reference. I appeal to the trial chamber to look carefully at what the witness said at T747, 748, and onwards. In paragraph 795 of the prosecution final brief, the prosecution claim that Župljanin conveyed the 10 August order to Stanišić with a delay to carry out the transfer of the camp to the army, and that he delayed it until the end of August. The defense is of the position that there was no delay. The order was conveyed on the 19th of August. Only 9 days later, upon receipt of that order, in view of the state of war and the fact that the communication system was not operational, the time period was reasonable. I will give you an illustration, just as my learned friend Mr. Žečević showed you an example at the level of Republika Srpska at the Banja Luka CSB, based on exhibits and evidence, what the scope of communications was in 1992 compared to 1991. Here you have the relevant figures. Your Honours, I will now move to a different topic, namely the takeover of municipalities and the division of public security stations. The defense is of the view that the division of SJBs and takeovers of municipalities were two completely separate processes. We want to highlight this. Župljanin's participation in peace negotiations was in contradiction from the very start to the actions taken by the crisis staff and the army. Župljanin met regularly with municipal leaders of different ethnicities long before the start of the armed conflict and encouraged cooperation between different ethnic groups in order to reduce tensions. At paragraph 129, the prosecution, yet again, misquote evidence when referring to Župljanin's contact with SOS and quote witness Radulović. They take his sentence out of context. Radulović clearly said who it was he considered was close to SOS. He said, Kesić, my head of the security service. And where is Župljanin in this? And Župljanin is being mentioned in that context by the prosecution. Your Honor, I will not dwell on Sanski Most or the takeover of municipalities because I am pressed for time. We dealt with these matters in detail in our brief. I would like to show up, or actually to refer you to P390, This is the chief of the public security station Sanski Most sending a letter to Župljanin, wherein it is said the Sanski Most police was not deployed, nor did it take part in the combat activities that were carried out by the armed force, by the parties to the conflict, because they did not have the necessary training, nor was that the purpose that they served.
Dalje, čas da se vratim na ključ još jedan.
Let me go back to Ključ and give you another example, Your Honours, of this cherry-picking of specific portions that are of testimonies that are then taken out of context. In paragraph 378, the prosecution quote what a witness said, and it was said that Župljanin said that by the 2nd of May, the change of uniforms was already a done deal and nothing could be done about it. But in fact, if you look at the following response at page 4745 to 9, you will see what it was that the witness said when he spoke about Župljanin. It was our understanding that he wanted to say that he was unable to take a decision one way or the other because some other persons or other organs were the ones who had already made a decision on this issue. We spoke to a person who was in no way able to assist us in that matter.
Časni sude, dalje.
Your Honours, at paragraph 392 of the prosecution final brief, it is stated in reference to Župljanin that both he and Karadžić knew that the police helped the army to arrest people. There is evidence that indicates that Karadžić informed the chief, Župljanin. Let's see where do we find this evidence. Transcript page 15980, witness ST 218. His Honour Delvoye asked him the following. And it's about Biljane. The witness said, we did not investigate into this further because it was committed by the army and criminal reports were already filed. It was well known who it was who perpetrated these crimes and we did not investigate them. Chief Karadžić was aware of it and probably through a regular report he informed the chief of the center. But this is only a conclusion on my part. His Honour Delvoye said, you said probably, so you're not quite sure. Answer, I am not sure because we never mentioned that topic.
Dalje, još jedan primjer.
Furthermore, another example of how the prosecution created their final brief and how they interpreted evidence. That's paragraph 456, where they claim, and they say, in early April, a meeting was held at the CSB Banja Luka, where Župljanin explained to the leadership of Kotor Varoš that all policemen had to sign a pledge of loyalty to the RS. Although the meeting was supposed to resolve any conflicts that may arise due to this request, Župljanin did not offer any compromise and addressed Đekanović. President, bang your fist and resolve this situation. Župljanin then said, allow Nedeljko Marić to be the chief of the Croats, Muhamed Sadiković to lead the Muslims, and Savo Tepić to lead the Serbs. all in all, those present, the context and the meaning that the prosecution reads
that portion of what you have just...
I follow your suggestion. This part particular wasn't incorporated in our final brief because that was the first time we were aware when the prosecution quoted this particular piece of evidence in his own final brief.
Ms. Corner, could you assist me and the court officer with the lines, please?
It's it's page 112 from effectively line 4 through to the end of whatever Mr. Karadžić quoted. line 11, we think. No, it goes on further. All right, okay.
Thank you. Yes, so that would be redacted.
Časni sude,
Honest. There are many such examples of misinterpreting evidence and taking things out of the context. You will find so many of them in the prosecutor's final brief that I should be standing here for 3 days to highlight every one of them. My colleague, Mr. Alexic, will go on and deal with some other matters, but let me repeat what I already stated at the beginning of my presentation. Look at the evidence. When it comes to the responsibility of Stojan Župljanin, do not read the prosecutor's final brief. Look at the evidence.
Really need to deal with. I don't know whether it would be appropriate to deal with them now or whether at the end of the day or tomorrow. I would submit it's probably better to deal with them now. One of them goes back to Mr. Krgović's giving evidence about translations. The second is the relation to Kotovaros.
Whether could we confirm from Mr. Krgović that we are effectively at the end of the day? I thought he was about to hand over to Mr. Alexic, in which case the few remaining minutes we could deal with these matters that you wish to raise. Is that where we are, Mr. Krgović?
Yes, I've finished my part of submission.
Yes. So Mr. Krgović will take the baton to Mr. Alexic will take the baton tomorrow morning. Yes, Ms. Corner.
Your Honours, it's, if we go back, please, to, if I can come to it, what Mr. Krgović was saying at page 96 of today's transcript. Sorry, it's maybe... It's actually before 96, where he's dealing with the document I raised yesterday, P583. Nah, that's the point. It's the next document that I've marked up. But page, I'm sorry, thank you very much. It's page 93, Your Honours. I'm sorry, I failed to mark it. Yes, P53. And this is, Your Honours, where I objected. He says that he's going to show you another document that applies to people who are unlawfully detained without any foundation or grounds for their detention. Well, it's not much better, but it's not what hostage means, as Your Honours know. Your Honours, before we dealt with that document, because it was such an important document, we had double-checked, as far as we're concerned, that that was the correct translation. No one has, throughout this trial, and this document is a reasonably early document, it may have come in through Mr. Nielsen, suggested that that was a wrong translation. It is therefore not for Mr. Krgović to give evidence that it has a completely separate meaning, and to go on to compound the offence of giving evidence by purporting to read what has been said in the BCS to be, and English, an illegible part of a document, which is P601, and that's what he mentioned at page 96, where he purports to give a translation, going along this theme of what this particular word is of a different word, but that translation does not appear. We have the hard copy of it. It's illegible. And so we say, Your Honours cannot take that into account. The evidence is closed. If the defence want to file an application to reopen the case to deal with that, they can do so. But we invite Your Honours to totally disregard what Mr. Krgović has said about that.
The short response, I suppose, Ms. Corner, is that that would be the course that the chamber would take. But unless I misunderstood Mr. Krgović, he seemed to have, and you would both correct me if I got it wrong, he seemed to have, resiled would be the wrong word, but modified, as it were, his challenge to the mistranslation, because, as you have indicated, the proper course would be to make the appropriate application. And where I understood him to place himself was that the understanding, I don't want to use the word interpretation, I don't want to use the word inference, because it's neither of those, but the understanding taken as a whole, and I'm putting aside wholly what you have just indicated would have been his interpolations of illegible parts in the BCSD read into the record. Let's ignore that. But what I understood his position to become was that we read the document, and this is in fact the effect. So in other words, it's a type of argument which could be properly advanced even if translation wasn't involved at all. We have a document in say, English, and everybody is English speaker, and counsel A says, this is the interpretation that you, the trial court, should find. The other side says the opposite. That's where I understood him to be at the end of the day. But if I got it wrong, then of course the chamber needs simply ignore the his effective supplementing of the record.
Your Honours, I would have looked at that when I got up to object to this, but except that he went on, and this was the part at page 96, to draw the analogy from document P601, where he says it should be it says the word illegible should be isolated individuals. This is a bad translation. This is I may say it's not the clearest what he is saying. This is the category that existed in our system, and as Mr. Zečević said, the prosecutor did not interpret the legal terms and the legal system in the way it existed in the Yugoslav legal practice. The term isolated persons or hostages, we all know that it was illegal to keep hostages, but this refers to people who were detained or kept without any grounds for that. Now, Your Honour, it's of course for Your Honours to read the context of the term hostages, but what now seems to be suggested is that Your Honour should take into account, about which again you've had no evidence, something about the Yugoslav legal practice. We say the word is hostages, it's properly interpreted, and the context makes it clear. And Mr. Krgović cannot now seek to go behind that by giving evidence. And that's the first thing. Do Your Honours want to hear from Mr. Zečević? I'm sorry, Mr. Krgović on this.
Your Honours, you understood me well when it comes to the first objection by Ms. Kone. I didn't say that it was a wrong translation, but it was the literal translation, and that the meaning of that term had to be put in the context of our former legal systems, what it meant and how we used it. That was the meaning of my interjection, because the term was not mistranslated, it was literally translated. I didn't object. I did not claim that the translation was wrong. Not for a moment. That was my position or intention. And when it comes to the second document that I read from the screen in the Serbian, when I read, the document reads isolation, and that is why it should be resent for translation, because it is very important that this document be put in the context of my whole presentation. I presented my position with regard to this document and how it should be translated, be interpreted.
Well, Your Honours, that's the problem. We've had no evidence at all about how that term should be applied in the previous, or was applied in the previous Yugoslav system. So therefore, we submit that Your Honours should ignore Mr. Krgović's submissions on this point, because that is giving evidence. And literally, the word is hostages. Your Honours can see the context, and it's a matter for Your Honours to decide what's meant by that. And I think that's as far as I can take that point.
Your second point.
The second point relates to Kotovaros, and Mr. Brown. And they did the same in their brief. Mr. Krgović said, and this is at page 104, I think. Takes the for heaven's sake. Yes, page 104, line 10, where Mr. Krgović says he's going to clarify the dilemma which the prosecution may have about the defense prosecution in regard to the health center killings. And he says that we founded the count of the indictment on the killings outside the health center and assert that it was committed by the special police on the Kotovaros minutes of meetings P46. We do not, Your Honour. We never have, and in the final brief, it is P81. Can I ask for it to be put up? P46 is a totally different thing. Your Honour, this is...
Your Honours, I object to this. This is rebuttal. Ms. Corner should not be allowed to present her position on this occasion. She shouldn't be allowed to do that now.
A total misrepresentation of the evidence. It's nothing to do with rebuttal. I am saying that Mr. Krgović, by saying that we found this on P46, is deliberately, as they did in their final brief, misrepresenting the evidence, first of all, of Mr. Brown, and secondly, of the prosecution.
However, you don't have the procedural right to respond to that. You could do that in your final brief, in your closing argument, because we presented my position in our final brief and during our case and the presentation of evidence in our case, and we only repeated it during our closing argument.
So, Mr. Krgović, if Mrs. Corner claims that the correct reference should have been Exhibit P81 and not P46, would you agree to that? Then we can settle the issue here and now.
No, Your Honor. My reference was to P46. I did not mention P81.
But I think the issue is here that a possible mistake may have been made by you by quoting 46 rather than 81. So if that was a mistake, then we can settle it. If not, then it is subject to...
Your Honor, I will check whether that is the case. I will respond tomorrow. I'm not sure. I said from the outset that P81 describes a different event, whereas P46... Actually, there were three different events that took place. P81 speaks about the killings in front of the health center. The other two documents that Brown used, P46 and the report of the first Krajina Corps, had nothing whatsoever to do with that event. The case is that Mr. Brown associated them erroneously with that event.
I'm perfectly happy we've dealt or I dealt with my final address on this. All that I'm concerned about is that he said we base the case of the crime on that document, and we do not. And we have never said that we did. It's P81. That's all. The rest leaving is for Your Honour to decide, having read that. But it is totally erroneous to say that we base our allegation of the crime committed by the special police on P46.
And to that extent, it should be patent from your final briefs. So there's nothing for us to...
I must go with it. It is not right that in a public speech, Mr. Krgović should make a total misrepresentation of what our case is about.
No, Your Honor, I must say, I must remind Ms. Connor of her claim. When she examined witness Brown, she suggested, based on the document by the first Krajina court, and Brown admitted that the massacre was committed by specials. That was her her examination. What was that by the basis for her claim that the special unit committed the crime? And when that claim fell through, then she changed the reference to P81. I am not misinterpreting things. I'm listening to the way the evidence was presented by the prosecution. I'm qualified to assess what the prosecutor's case against my client is.
No, but Your Honour, no, very well, but I want it just very clear. As I say, this is in public, and I think it's right. At no stage have we ever said that anything other than P81 was the basis for the allegation. The later accepted misunderstanding by Mr. Brown of the later document, which Mr. Krgović showed Mr. Brown is right, but the allegation has always been based, and if Mr. Krgović checks off our brief, our pre-trial brief, you will see on the document P81.
Yeah. So we've heard you, and we now have it on the record, and we take the adjournment to 9 o'clock tomorrow morning.
All rise, we will